Good morning, officer. You indicated on direct that you worked at Timberlake for a week and a half,
Yes, sir.
and that Officer Dalton was your training officer,
Yes, sir.
and he was showing you what to do.
Correct.
And was it your perception that he was familiar with the procedures in Timberlake?
Yes, sir.
Had he ever conducted a traffic stop other than this one?
Yes, sir.
Had he ever conducted a traffic stop without calling for backup?
Yes, sir.
Okay. How many times in the 10 days you worked there, or week and a half that you worked there?
About 4 or 5.
Okay. And how many, other than this stop, how many times did you call for backup on a traffic stop?
When I was there, just that one time.
Just the one time? Okay. And if you had questions, you looked to Officer Webb for advice?
Correct.
Now, you indicated that you found that what you thought was suspicious was, your word, the driver of the Captiva whipped it into a parking space.
Yes.
That was suspicious.
Yes.
You didn't arrest him.
Nope.
You didn't approach him.
No, sir.
Didn't go closer.
No, sir.
Didn't take any video footage of that.
No, sir.
Right? Just sat there.
Yes, sir.
And then you said he was coming back and forth from the gambling establishment to the car.
Yes, sir.
No video of that either.
No, sir.
And you don't know what he was doing in the car, right?
No, sir.
And you didn't take video of it.
No, sir.
Okay. Now you're guessing that that's indicative of drug use, but
Yes,
that's
sir.
only a guess.
Yes, sir.
Okay. No evidence of that at all.
Other than the bong in the
You
center
weren't
council,
aware of
yes.
the bong at that time.
Correct.
So when you're observing from across the street, after he whipped in, which you thought was suspicious, you're seeing him come in and out, which again, indicative of drug use, but you don't know that. That was a guess.
Yes.
Now, how many, you said you were involved in 4 or 5 traffic stops in Timberlake?
Yes.
How many traffic stops have you been involved in, roughly, as an officer?
Well over 100.
Okay. And in your well over 100 stops, how often do you focus on the passenger in a traffic stop as opposed to the driver?
Only when they don't have a seatbelt on, and by the state of Ohio, you're allowed to identify that passenger without a seatbelt on.
Okay. But how often has the focus been on a passenger rather than the driver on a traffic stop, in your experience?
Quite a few times.
Okay. Based on what?
Based on if they're driving a car that's perfectly fine, and then all of a sudden they get it on a tow truck to get it out of a parking lot.
And that's happened to you before?
Yes.
How many times?
About 4 or 5.
Okay. Anything illegal about calling a tow truck?
No.
Okay. And if someone has a suspended license, wouldn't the best choice be to have the truck towed?
No.
They shouldn't have it towed.
No.
They should drive with a suspended
They
license.
should drive, get cited for their traffic violation, and then have the officer with his discretion either let them drive the car away or not.
So just to be clear, your testimony is you should break the law.
Yeah.
Okay. And how long have you been a police officer?
Since 2016.
And you were at the Akron Summit Sheriff's Police Academy?
University of Akron, Summit County Sheriff's Office.
I'm sorry,
Police
University
Academy.
of Akron. And was that one of the policies that you learned there? That
Discretion,
you break
yes.
the law?
Discretion, yes.
I didn't say discretion, but to advise people to break the law.
No.
Is that something that Officer Webb imparted on you?
No, sir.
Is that something you're just making up today?
No, sir.
Now, you indicated that the tow truck driver no longer wanted to deal with a Captiva. Is that your testimony?
Yes, sir.
Is it fair to say it was clear to him that there were several officers there, all of whom were much more interested in the Captiva than his tow truck?
Yes, sir.
And is it fair to say your perception is he was ready to get out of there.
Yes, sir.
So when you're saying it's voluntary, that's a little bit tortured, right?
Explain.
He wanted to leave.
The tow truck driver?
Yeah.
Yeah, he wanted to leave because he had been put under the pressure of DRE.
Okay. And he wasn't cited with anything, was he?
No, sir.
Now, you said you made some observations inside the vehicle in plain view. Where were you located when those observations were made?
On the passenger side of the vehicle, as it was on the roadway.
On the roadway?
Yes, sir.
Wasn't in plain view when it was on the tow truck?
No.
And when the tow truck was first pulled over, did you have any interaction with the tow truck driver?
No, sir.
Okay. You went right to Mr. Ward, right?
Yes, sir.
Did you request the canine?
No, sir.
Did you observe the canine?
Yes, sir.
And if I understood your testimony, the canine alerted to a toolbox from the tow truck, not from the Captiva.
Yes, sir.
Okay. In the parking lot that you pointed out, is that parking lot located in Eastlake or Timberlake?
Eastlake.
Okay. And do you have jurisdictional limitations as far as going into Eastlake for something like this?
No, sir.
What was the traffic like on Lakeshore Boulevard this night?
Prior to the stop or after the stop?
During the stop?
During the stop, it was light traffic.
And where was the tow truck and the bed of the tow truck located in terms of, was it on the road or on the side of the road?
Before the traffic stop or during the traffic stop? During the traffic stop, it was on the right-hand side of the road.
Okay. And are you aware of Timberlake's inventory procedures?
Yes.
And what are those?
Inventory of a vehicle either gets towed or they let it sit on the side of the road until the valid driver comes and picks it up.
Okay. And in this situation, there was a decision made to tow it?
Yes, sir.
Okay. But, and again, just to be clear, but your understanding is that Timberlake does have a policy?
Yes, sir.
Any other valid drivers at the scene that you're aware of?
I believe just the tow truck driver and his wife or girlfriend, whatever I don't know who it was.
Mr. Ward's?
Yeah, I had it mixed up. He would say his wife and his girlfriend, and apparently he's got two of them.
Okay. It's just a significant other?
Yeah.
Okay. And she had a valid license?
Yes, sir.
Nothing further, Your Honor. Thank you.
Mr. Fatiga questioned Officer Kangalos about the Timberlake Police Department's inventory search policy. He argued that under Florida v. Wells, an inventory search must strictly follow standardized department procedures and cannot be used as a pretext to search for evidence. The defense pointed out that Officer Kangalos admitted department policy allows a vehicle to remain at the scene if a licensed driver is available to take custody of it. According to the defense, bypassing that option and choosing to impound the vehicle instead raised questions about whether the search was truly administrative or investigative. Mr. Fatiga also questioned the officer about jurisdiction. Officer Kangalos acknowledged that his authority was limited to Timberlake, while his initial observations of Mr. Ward occurred in Eastlake. The defense argued that beginning an investigation outside the officer's jurisdiction could affect the legality of the detention and any evidence obtained afterward. During cross-examination, Officer Kangalos testified that a person with a suspended driver's license should drive the vehicle instead of calling a tow truck. The defense challenged this statement, arguing that law enforcement officers are expected to prevent violations of the law rather than encourage them. Mr. Fatiga further argued that these admissions, together with the officer's actions during the investigation, weakened his credibility and supported the defense's position that the stop and subsequent search lacked sufficient legal justification under the Fourth Amendment. Officer Kangalosi testified that the K-9 unit did not alert to Mr. Ward's vehicle. Instead, the police dog alerted only to a commercial toolbox located on the third-party tow truck. The defense argued that a K-9 alert must be linked to the specific source of the odor and cannot automatically establish probable cause for a different vehicle. Based on that testimony, Mr. Fatiga contended that searching Mr. Ward's car without an independent legal basis violated the Fourth Amendment and could require the evidence to be suppressed. The next witness was Officer Dalton Webb. Following Ms. Gold's direct examination, Mr. Fatiga began his cross-examination. During questioning, Officer Webb acknowledged that he had not documented or cited committed any violation of Ohio Revised Code.
Officer, you indicated that when you first saw the Captiva, what stood out was it had heavy tint. You
Yes.
recall that?
Yes.
Okay. And the tint was so heavy, you were contemplating issuing a citation.
It was going to be a traffic stop if I could have found and stopped the vehicle.
Okay. And you lost track of the vehicle at that point?
Yes, until we circled the parking lot multiple times, but by then, Mr. Ward was out of the vehicle.
Okay. But so you didn't see him park initially?
No, but I did see him operating the vehicle.
All right. Let's answer the question I asked. You didn't see him park the vehicle. That's the question. Yes or no?
Correct.
And you saw him operating the vehicle, but you didn't issue a citation at that point?
Because we cannot locate him.
Right. And if someone is under suspension, you wouldn't advise them to drive while they were under suspension, would you?
No.
Now, you indicated that the seat was tilted back.
Yes.
You recall that testimony?
Yes.
And was the seat tilted back when you first saw the Captiva on Lakeshore?
Yes.
How were you able to tell that, given the heavy tint?
Through the front windshield.
Through the front windshield, you could
Yes.
tell it was, okay. As he's passing by?
As I'm looking directly into the car before he makes the left-hand turn into the plaza.
Okay. And when you made the left-hand turn, then you lost track?
Yes.
And who else was in your cruiser?
Officer Cangelosi.
Okay, and he was in the passenger side?
Yes, sir.
Now, you indicated that the Captiva was registered to someone was registered to a Sandusky business. Do you recall that?
Yeah, well, Port Clinton now.
Yeah.
Yeah.
But nothing illegal about that, right?
No.
Okay. It had a legal registration.
Yes.
And you verified that Mr. Ward had no warrants,
Correct.
didn't have anything illegal on him.
Correct.
You didn't see him doing anything illegal.
Besides operating a motor vehicle under suspension.
Hold on, let me finish. When he's walking back and forth, you didn't see him doing anything illegal when he's walking from the gambling establishment back to the Captiva.
Not that I know of. He could be.
But not that you know of.
Correct.
And you indicated that you got the canine involved because of the tow truck driver's behavior.
Yes.
And at one point in the footage, you indicated that he was going to get it, the tow truck driver was going to be cited for OVI, and that the tow truck, as well as the Captiva, were going to be towed. Do you recall that?
Yes.
That didn't happen, did it?
No.
And were there any other valid drivers that came to the scene during the pendency of this stop?
Yes. I believe it was his girlfriend or wife, Officer Lawrence at that time, handled that situation with her.
Okay. And how heavy was the traffic on Lake Shore during the pendency of this stop?
Pretty moderate.
Pardon?
Moderate.
Okay. And where was the tow truck and the Captiva, on the side of the road or in the road?
On the side and in the road, because there is a ditch line there.
Now, you said, the report I have is, I believe there were drugs in the car. You recall that?
Yeah.
Okay. But and that's based on him walking back and forth from the gambling establishment to the car?
Just the behavior. It's all,
You could just tell, right?
well, with criminal behavior, with, seat being leaned back, heavy tinted windows.
Yeah, but you could just tell, right?
Yeah, with my experience, with all those indicators.
Okay. And the indicators are the tinted windows?
Tinted windows, vehicle being registered to a business, seat being
But there's
tilted back.
nothing illegal about that, is there?
With the windows, yes.
Well, you didn't cite him for that, did you?
No,
And did you ever measure the windows?
we did not at that time.
So you don't really know what the tint is.
Correct.
All right? And you're judging the tint at night.
Well, also during the day when I seen Mr. Ward.
Okay. But that wasn't at this stop, right?
It was prior to that stop when he was operating the vehicle.
Okay. But you didn't stop him then?
I wasn't able to locate him. He wasn't in the vehicle.
Okay. And you didn't see him park the vehicle?
No.
Now, if I understood you correctly, the K-9 alerted to the tow truck.
Yes.
You would agree that there's no connection between Mr. Ward and the tow truck. He was merely a passenger.
His vehicle was attached to a tow truck, which makes it one whole vessel.
Okay. And the K-9 alerted to the tow truck.
Yes, right below the driver's side door.
And Mr. Ward wasn't driving the tow truck.
No.
You never saw him on the driver's side.
Correct.
There's no real connection to where the dog alerted and Mr. Ward. I guess that's the larger point.
Yes, where the driver's side door of the vehicle is right above where the dog alerted.
Right.
So there's the connection. The vehicle that was on the tow truck was Mr. Ward's at the time when he was operating it.
But the dog alerted to a toolbox that was on the truck.
That was directly below the vehicle.
So you're saying it didn't alert on the box. That's your testimony?
It alerted on the...
Yes or no?
It alerted on
Yes
the
or no?
tow truck.
Yes or no? Alerted on the box or it didn't?
It did.
Pick something.
Hey.
I'm sorry. I'll withdraw that. And then you indicated that you did a warrant search for Mr. Ward?
A CCH search, criminal history search.
Yeah, and nothing came back?
With his criminal history?
No warrants?
Correct.
And as to the driver of the tow truck, was it your perception he just wanted to get out of there?
Correct. He didn't want nothing to do with the remaining of the situation.
And he was getting a break because you're not citing him even though there was a registration issue?
It was a learning matter on the tow truck's behalf with the not securing the vehicle correctly, getting his registration fixed, and also going to get an eye test to possibly get glasses.
Okay. And you gave him warnings for that?
Yes.
Sent him on his way?
Yes.
One moment, Your Honor.
Code Section 4513, 241 in his original reports before giving his testimony. The defense argued that officers are expected to record all significant observations and evidence during the initial investigation, and that failing to mention the alleged window tint violation until later raised concerns about the reliability of the officer's account. Officer Webb also testified that he believed drugs were inside the vehicle based on Mr. Ward's behavior and several indicators he considered suspicious, including the driver's reclined seat. The defense challenged whether those observations alone were sufficient to establish the legal justification required for a warrantless search. The defense argued that the Fourth Amendment requires officers to have probable cause before conducting a warrantless search of a vehicle. Such probable cause must be based on specific, objective facts that would lead a reasonable officer to believe evidence of a crime or contraband is present. During his testimony, Officer Webb acknowledged that his records check showed Mr. Ward had no active warrants, was not committing any other criminal offense, and no contraband was found on his person. The defense maintained that once the purpose of the traffic stop had been completed and no additional evidence of criminal activity had emerged, there was no lawful basis to continue detaining Mr. Ward Detamar. Fatiga further relied on State v. Dunlap, arguing that a traffic stop must end once the original purpose of the stop has been fulfilled unless officers develop new, legally sufficient grounds to extend the detention. According to the defense, continuing the investigation and conducting a warrantless vehicle search without independent probable cause violated both the United States and Ohio constitutions. As a result, the defense argued that any evidence obtained during the search should be excluded under the fruit of the poisonous tree doctrine. Following Officer Webb's testimony, Judge O'Donnell invited both parties to present their arguments on the motion to suppress.